A constitution is there fundamentally to bind the government.
Who granted the government the authority to alter the constitution?
We should be understanding morality. We're the judiciary. There's no such thing as judges. The people become the judiciary. Constitutions are there to protect people's individual rights. And
A codified constitution should only ever come from the people by the people.
if you truly want to be free, we should be defending truth.
Hey guys, Gavin here, Sovereign Empowerment. I'm joined once again by Damien. Damien, if you don't know, if you've not seen the other videos, Damien has an awful lot of knowledge about the Constitution. Our Constitution, I should say, 1215 Magna Carta. He has a lot of knowledge about the history that surrounds that brought us into the Bill of Rights. And the reason we're doing this video today, I think there's a little bit of misunderstanding. Damien certainly agrees with that one around the 1215 Magna Carta versus the Statute of the 1297 and thereafter. Damien's going to go through some slides and he's going to put a lot of other truth out there that I think, or we think, is not being talked about. It's maybe not even known about. Maybe other people haven't read the history books to know about this stuff, but it certainly gives you a different spin on the current narrative around the 1215 Magna Carta. Now, with that said, and Damien, I've never spoken to Damien about this stuff, but there's other stuff that I track that I haven't really put out on the channel purely because of the issues with saying certain things on these social media platforms where you might then get shut down. So I'm going to be a little bit cautious about how I say this, but it's absolutely relevant for what we're doing now, because there's going to be a moment of time very soon where things are going to start obviously collapsing. This entire system has to collapse, and it is being collapsed right now. We're living it, okay? But there's going to be a moment in time where everybody is aware of that stuff happening. And the word constitution is going to be on everybody's lips, because we will be returned to constitutional law in this country. That is happening. We can prove a lot of this stuff now. So what I wanted to do was just give a few things that you could potentially go and look, not potentially, you can, if you choose to, look into this stuff yourself and validate a lot of what I'm saying about this collapse playing out and it being done under military control. There is a global military alliance in play. So back in 2020, something happened with regards to elections in another country. We know about that. That was an overt act of war by a number of nation states. It's worth checking out an executive order which you can find on the White House website, okay? Legitimate website. And I'm going to give you a number. It's 13848. Read that executive order. Take a note of when it came into play. It was 2 years before 2020. Look at the relevant acts in there, especially the ones that give global reach. Also look at Executive Order 13818. Again, look at the acts that give global reach and authority. Also understand that under the constitution of the other country, you know what I'm saying here. If there's an election fraud matter, under that constitution, the individual who was in charge at the time would remain in charge and also remain the commander-in-chief of the military of that country, okay? You can put the dots together. What that means is that then what happened thereafter was something called the War Powers Resolution Act, Title 50 USC 1550. You can Google it. You can bring it up. If you read it, I promise you will start to create a very different perception of the reality you currently think you are in. The reason I'm saying this now is because we're so close to this stuff going down. Kit, I'm just going to start talking about it, okay? So you want to look at Title 50 USC 1550. There's your starting point. War Powers Resolution Act. Understand the global authority that provides people, a certain country, in conjunction with a global military alliance. Everything you think you are dealing with right now is about to end. It's very soon going to end. It's this year. That said, this is why this conversation I feel is important about the Constitution. Damien, over to you, my good man.
So I'm going to address certain narratives that I've seen knocking around social media and other places. And I think people are a little bit confused as to what our constitutional law is. So I'm talking about the Magna Carta 1297. The legislature can write legislation. It has the authority to do that. What the legislature can't do is write constitutional law. What needs to be understood is that statute has fundamental limitations, meaning it can be repealed or amended. Government had no business attempting to rewrite constitutional law using statutory law to do. It was treason. They shouldn't have been operating in that manner. What it also allowed them to do further down the line was start the repeal process. It is self-evident for all to see that the Conformatio Cartarum, the 1297 version, has been repealed, amended, and even the original translation has been altered in places. Government can play no part in the writing of constitutions, and it makes sense to apply this logic, as its sole purpose is to protect the people's liberties by binding the government to adhere to it. Not much of a safeguard if governments are in control of that mechanism using statutory law. So the main things to take from that slide is that constitutions bind governments. They don't play any part in creating them. Statute law can be amended, can be repealed, and can be written. But because a constitution is permanent, it comes from the people. It can't be statute because of them fundamental limitations of statutory law. My point on this slide is that you've got constitutional law, which is the 1215 Magna Carta. That is what applies. That's what your constitutional law. The 1297 version, it's got articles contained within it that are the same as the 1215, but it's not needed. Does that make sense?
Absolutely makes sense. And look, as people go through this just looks so obvious because the truth, I always say this resonates. Isn't it obvious that a codified constitution should only ever come from the people, by the people, and that no one above the people has any authority to do anything because the definition of a free people is the people have the power. These are just obvious facts. These are things that we know about. So when you look at what's actually going on and you look at some of the narrative out there, it's just ridiculous. It's ridiculous when you just go to simple truths. Obviously, this is the case. So yeah, it absolutely makes sense.
It's because a constitution is there fundamentally to bind the governments and to protect people's individual rights
Against tyranny. Funny that.
If the governments are in charge of that mechanism, then they can just write whatever they want.
Yeah,
they can
as
write
they
themselves into constitutional law. They can write themselves as an authority.
As they do.
Exactly. Yeah, I just wanted to make that point. That the main point there is that the Constitution is meant to bind governments. So if it's in statutory form, it's got limitations because of the repeal process, the amendment process. And you can see, if you look up on the legislation website, you can see it's been mutilated.
And that for me is another obvious fact point, because anyone with half a brain that were to look into that can see the things that they've mutilated are the very things that actually give the people that authority and power. So again, it doesn't take Einstein to work out why that's been done. And again, it just supports what you're basically saying.
Yeah, pretty much. That's what it is. The 1297 version does not contain the main articles of the original Great Charter. It does contain the main articles of the original Great Charter, but this alone is no reason to suggest that the 1297 Magna Carta invalidates or supersedes the Great Charter. If the main articles of common law in the 1215 original Great Charter already exist, then the need for the statute version is not required. It just means that when future legislation is written, it must align with the constitutional law that already exists, which is the Magna Carta 1215, law of the land, common law trial by jury. Whether or not that is something the different branches of government understand is irrelevant and is not an excuse to ignore real constitutional law. I would also argue that people using the 1297 version because they feel it is a language the judiciary understands, which is statute, is compounding the fracture. What people should be doing is holding branches of government to account under the constitutional law that binds them. So this is a problem because I've seen obviously people use the statute version because they feel that that's what they're going to recognize in court. When you're talking about constitutional law, That's the top of the tree, main authority. If you're bypassing that to use statute because you feel that you've got more of an argument or an easier ride, that's just encouraging the lies behind it.
The other point of that actually as well is anyone's ever tried using that in the court, don't expect them to listen to that. Even though it's statute and it's bullshit, it's still inconvenient in the judicial system, given the things they're doing to people.
Yeah.
It's the same point that the whole system's rigged, isn't it? We've gone through that
Well,
time and time again.
if they play a part in writing this statute, then it gives them the green light to do whatever.
Yeah, you're right.
Because if there is any sort of wiggle room, then what they can do is just amend it.
Yeah. And again,
it's just repeal it or replace it.
And that's been done.
People are like, oh, the implied repeal and all. That's not the case. These kind of documents are just a little bit stickier to deal with. That's all. If you recognize the treason that's been committed by politicians down the years, then you'll recognize it's easily done.
Yeah. That's why we have to go back to the constitutional rule of law. It's the only way to remedy everything that's happened, because this has been going on for hundreds of years. It's not a new thing.
Like I said, common law, the law of the land, is top of the tree in that system.
Yeah.
Legislation or anything coming out of Parliament has got to align with your constitution, because once it gets to the trial by jury stage, it's just going to get annulled.
Yeah.
Because it's unconstitutional. And then you've got the angle of private prosecution of the people who work for the legislature who are writing this stuff. The public servants can be prosecuted under constitutional law.
Yeah.
So it kind of safeguards and kind of discourages people from doing that kind of stuff. So you filter out all the immoral people within government with them processes.
And again, it's pretty obvious why that stuff doesn't exist now, right? It's so obvious when you look at today and what's going on today. And then you look at what has been removed and what's been done. It tells its story, and it's a pretty obvious story. And this is why I don't understand the other arguments to say, oh, it's not the Constitution, and this is this, and this is that, and blah. It makes no sense. The other arguments make no sense.
I think one of the arguments is people don't recognize it as constitutional. They just recognize it as a peace treaty to avoid war, which is wrong, because the articles of common law in the Magna Carta are constitutional, and that predates 1215. You can go back hundreds of years. You can go back to Alfred the Great. You can go back to Edward the Confessor. These laws, trial by jury, they were in place. People looking at the Magna Carta as if that's the start of trial by jury or the start of common law is a falsehood. Most people start at the Bill of Rights.
Yeah.
They don't look at anything that predates the Bill of Rights.
I think a lot of that's also, and I can speak for myself, is that when you don't know what you don't know, you're learning what you learn, and you come to statute and the Bill of Rights. But even then, there's a lack of comprehension in the early days of what statute even is. So you accept that as that's what it is, right? It's this statute, and here's the Bill of Rights, and that's my constitutional statute. It's only as you go through your journey and you learn more and more that more penny drop moments come in, and you start to realize, hang on, there's a problem with this too. This isn't, because everything's a bloody lie. And it's the realization that everything's a lie that for me starts to disconnect you energetically from the things you are holding as, there you go. This thing's on a pedestal. That's our freedom. No, it's not.
I think people fight this kind of stuff, but they still see judges' decisions and all that as authority, as case law and that. And it's not. What it is that the people are actually in that position of judging, and that the roles are reversed under the Constitution. And that's the problem for a lot of people to even believe, because of their experiences. So that's why, because all this stuff is disregarded in this distorted system, people are like, well, what can we use? They just accept rogue public servants. And that's a problem. But because we haven't got the numbers that are standing under constitutional law to make any sort of difference at this time, because I don't believe the knowing process of this is there yet, or the understanding isn't there. I think people need to understand it first.
I would say on that, we haven't really spoken about this stuff, have we? But there's going to be a rug pull moment coming up very soon where that is going to become one of the topics where everybody's going to want to know about it. We just need a little bit of external help, I think, to nudge us in that direction en masse. So that's coming because if we understand that entire system's corrupted and a lot of bad stuff's being done, just to keep it really simple from a black and white perspective, then everything that's been done has to be undone. And
Yeah.
then all of the things that are currently existing that are unlawful, county court, magistrates courts, the PCN fine system, all of the breaches, the Bill of Rights even, that's all got to go. And
Yeah.
so if you're getting rid of all of that in a scenario where that's all going, which it is going to be, it will naturally have to be, we'll have to naturally be talking about a constitution here.
I just want people to understand how powerful our constitution that we've got now and the trial by jury, how important that is, because that has to be central to anything that happens in the future. Because if that isn't in place, to me, it'll just be another tyranny.
I agree.
It'll just be another dictatorship because the people have to be in that position of judging anything that comes out of Parliament, legislation wise. They need to be in that position.
Completely
You know,
agree.
the whole system, the common law system, even when we talk about the head of state, that role is important in this system to protect. If they're not refusing royal assent to legislation that breaches constitutional law, then they need to be removed from office. And that's the end of it. And the people are in control of all them branches under this system. So that safety mechanism from a potentially criminal government is there through trial by jury because the people become the judiciary. They become the legislature with the power to annul legislation. And then you've got access to cost-free prosecution, which we haven't got now.
No, that's right.
We have got it. It's just that we haven't got access to it because that constitutional law has been usurped. And until people recognize that, if they continue to move with this distorted system that we've got now, then it's just a continuation. It's just a cycle of the same behavior. But we need to raise our own consciousness. We should be looking at this stuff. We should be learning it. We should be understanding morality, which is obviously exercised. Even your consent is exercised, trial by jury. All this stuff where we're like, oh, I do not consent and this, that. Okay, you do not consent, but how are you exercising that? You can't just walk into a system and say, oh, I don't consent with that. It doesn't apply because under constitutional law, we're the judiciary. There's no such thing as judges in this system. The people are the judges. The judges are the conveners. They just convene the court, whatever they need to do.
And just to come in on that as well, again, I always just revert back to just common sense and stuff. If you're weighing this up right now and you go, right, first you've got to accept that we have a rigged system. It's a very bad system. The question is, do you try and fix a system that really was rigged from the get-go? Or do you return to what the constitution is we're talking about right now? So when you hear what Damien's talking about with regards to trial by jury, I can't conceivably come up with an argument to say, no, we should keep what we've got and just try and fix the bad stuff versus trial by jury power to the people. Like, it's a pretty obvious decision, isn't it? What we should do.
Yeah. If we haven't got these safeguards in place, then the potential for governments to become criminal in nature or a head of state is there.
Exactly. And so the potential for that to happen, it could be argued that maybe that is happening. Who knows? I'm not saying it is happening, but we know what's happening. Do you know what I mean?
You know, what have you got in the Bill of Rights? In the Bill of Rights, you've got the choice to petition the king. Doesn't hold any weight at all, does it? It doesn't put us in a position of power because a lot of the time it just falls on deaf ears.
Again, another thing. Look, anyone that gets PCNs, speeding fines, all that stuff, all of that is illegal under the Bill of Rights. The Bill of Rights is statute. It's meant to be primary statute. Yet there's what is it, £1 billion? I don't know how much that industry is per year. But that's going on, being facilitated by the very same system that other people think needs to be fixed and can be fixed. We're talking about bringing back trial by jury. But again, it's a no-brainer.
If them kind of cases hit a trial by jury, which all cases should hit trial by jury because we know the score with magistrates courts and summary trials, you're just being judged on the legislation. And if you breach the legislation, it doesn't matter whether that legislation's lawful or not.
Exactly.
If that's a trial by jury, you might have breached it. But if there's no victim, then there's no crime, is there?
Exactly.
the jury might be like, he's broke the legislation, but is that legislation lawful? Has he committed a crime? Has he caused harm? The answer is no in most cases.
It just brings common sense back to the system. It's distinctly lacking. And we've all lived the last 4 years. We know that's distinctly lacking. We know why. This prevents all of that. What we've been living through would not have happened had trial by jury still been in place.
But people have to be ready for this. They have to raise their own consciousness to govern themselves in that way.
I would suggest that those people are going to get a very big helping hand with that very soon. And it will be the topic. It will be something that we'll all be discussing.
It's got to be, because
100%.
At the moment, I would say the majority of possibly the world, not just our own population, are in that status mentality. It's a safety blanket for them to be governed in this way. They don't want the responsibility of this kind of stuff. They want somebody else to make those decisions for them. But if you truly want to be free, because that's what the question is, it's about whether you want freedom to live how you want to live, or you want to be a slave. That's what it is. You want to be taxed and all that kind of stuff. And you're happy for government to step way outside its jurisdiction and start dictating how people live their lives every day. That's the question, really. At the end of the day, Gavin, people don't even know we've got a constitution.
That's right.
They don't even understand the articles of common law. They don't understand trial by jury. They don't know what was in place before. They're just happy to accept whatever rhetoric that the government feeds. And even people within the freedom movements have got that mentality. They're just ignoring constitutional law. They're not holding branches of government to account under the law they should be doing. They're just saying, oh, they don't recognize this. No, that's irrelevant. This is factual. This is truth. A judge or somebody, a public servant can't just ignore constitutional law and start trying to deal statutes. That's not how it works. That's not lawful. It's not just. It's what we've got at the moment, but that's where the pushback needs to be aimed, surrounded around. Even if we're not getting the results that we want at the moment, it again is irrelevant. This is about calling out wrong behavior. It's about calling out the lies. It's about calling out the breaches of our constitutional law that have happened over hundreds of years.
Yeah,
we shouldn't just be accepting and just accept what this judge is suggesting is reality, because in reality, all them things have taken place to basically take apart our individual rights, and that needs addressing. That need people stepping up to the plate. People can take steps toward showing allegiance to the real rule of law, to real constitutional law, and not this fake, distorted rule of law that we've got now, that everybody thinks is acceptable, to travel into that distorted system and try and find remedy in it through statute. That's just like accepting the whole illegitimate system because you found a way, a little loophole that might result in a few individual wins. That doesn't make sense. I know people are doing that, and I know people are in certain positions where they haven't got a choice at the moment, and I get that. I accept that. I'm in the same boat in the sense that I'm trying to do certain things, but what I want to do, because I haven't started this process, I haven't started writing notices to public servants, to the council, saying that what they've done, what they continue to do is treason, but that's what we should be doing, really. We should be holding them account on the constitutional law that exists, not constitutional law that we believe is constitutional. This statute is irrelevant in the sense that the constitutional law that exists, this doesn't need to be written. It doesn't even need to be used. That's where people need to look and start educating themselves. There's loads of sources. Democracydefined.org will give you an insight on everything. Trial by jury, inside out. It'll tell you, it's got loads of articles about usury and the creation of the Bank of England and all kinds of good stuff to read. You've got Wilkie and commonlawconstitution.org, full of information where I go all the time. to read stuff and to recap on stuff. People have to take that responsibility to do that for themselves, though. Because
Completely agree.
it's not going to happen otherwise, Gavin. It
Yeah.
just, we'll continue to ignore this. And this should spark within the freedom movement now and what people are doing within the legal system. There's loads of stuff out there. Will Keats done loads of videos. It should be sparking the conversation, not to fight and disagree, but to raise this conversation and come to some sort of agreement or on steps to move forward that is going to create real change.
I agree with you, mate.
That's how I see it. The Great Charter is not statute law, it is customary law. Therefore, it cannot be amended, repealed, or superseded by government-made law legislation. It predates Parliament, so it played no part in its creation. That isn't the main reason, by the way, but it does predate Parliament. It's a fact, and it's in the history books. So, if the 1297 version invalidates or supersedes the Great Charter, then my question is, who granted government its authority to alter constitutional law? The true nature of a constitution is that it is binding on government and is established by the people. No statute Parliament legislate can repeal, amend, or supersede it. Regardless of what the political regime might think, the Magna Carta 1215 and the Articles of Common Law contained within it are still binding on all government personnel. The Constitution, Magna Carta 1215, sits above statute law, and that is the reason Parliament is not sovereign, even though that is what is claimed. So if constitutional law sits above statutes, then it's the people who are sovereign, because through trial by jury, we legislate because we're the final dictates on what is finalised. Even if the head of state gives it royal assent, once it hits trial by jury, that's the melting pot. That's where we prove that we're at the top of the tree by judging not only the defendants, but the pieces of legislation that have brought him into court, him or her. So we have the power. We're not told this either. This should be being educated into people, into schools, into everything. It's probably not even being educated into law school. It's beyond belief. How is this being ignored? Because it's basically the remedy. You're ignoring the very thing that is going to set us free, that is going to put us in a position where our individual rights can't be breached. Again, it's not statute law. It can't be touched. It can't be amended. I'm predominantly talking about the Articles of Common Law that are important. I'm not talking about the whole document because some of it isn't relevant. Article 39, Article 40, two key articles. Article 61 gives us the protection, gives us the remedy for the rogue government, for the rogue regime, for the criminal head of state, however you want to look at it.
Wasn't that actually used in recent times as well?
It was. It's another thing that people tend to sidetrack. But it was actually invoked in 2001 surrounding the Treaty of Nice and giving away more power to the European Union.
And this was the barons doing this?
This
using
was
the 1215 Magna Carta?
Yeah, this was the 25 hereditary barons that invoked it. But what is even more important than that is that they petitioned the Queen. And the Queen's secretary, personal secretary, responded like on the 39th day or the 40th day, I can't remember now. Now, if the Magna Carta was invalid, if it had been annulled, if King John gave England away, if he made Pope Innocent his feudal overlord, then why didn't the Queen just state that? Why didn't the Queen's secretary write back and say, I'm sorry, but this is completely invalidated because in a few years prior to 1215, King John made Pope Innocent III his feudal overlord. He basically gave England. How ridiculous does that sound?
I mean, that's just, it's just crazy, isn't it? Who gave him authority?
He didn't have authority.
Is it the Constitution for the people, by the people? So how on earth does he do that for the people without the people having a say?
What people need to understand is that it was a limited monarchy. He had limitations placed upon him through his coronation oath to abide by the law of the land. Magna Carta was just reiterating that he'd breached common law, he'd breached his coronation, he'd breached the law, he broke the law. He's guilty of some of the worst crimes against his own people that a head of state is committed.
So he breached the coronation oath well before the Magna Carta came into play because of everything that he was doing. It will be essentially crimes against humanity, crimes against his own people.
You can't just decide to make Bafali treaties with a foreign state.
Yeah.
Okay? And say, do you know what? I'm giving England to you. Will you protect me?
Just to come in there now, like at this day and age now, I would suggest most of this audience is aware enough to know when we start talking about the Pope, we're not necessarily talking about the Pope in a godly sense, shall we say. We know the truth about that whole situation. So again, common sense, joining the dots, going back at that time. How on earth?
I'm just talking about the Church of Rome.
Yeah.
I'm talking about Pope Innocent V just being a bit of a tyrant himself.
Think about it though. That whole institution, as we know it, is not what we've been told it is. So we're joining dots here by saying there's a narrative out there say John had the authority to do exactly that, got the Pope in, annulled the Magna Carta, and then they come up with the 1297 version of Statute. But the players involved in all of this, doing this stuff, you have John, who was committing crimes against his own people, right? Inhumane crimes against his own people. You have the Pope representing the institution that we know what that is. This narrative playing out, it doesn't take too much to join the dots to see that this is all subversion and bullshit to create a narrative. And then if you allow a few hundred years to elapse and a lot more corruption to take place and a few more treasonous acts to happen, is it any wonder we get into this situation now where it's a little bit confusing as to what really happened? But what Damien's doing, just to finish this bit off, is just putting in here some common sense questions. Who granted the government the authority to alter the Constitution if the Constitution is meant to be for the people, by the people? How does that happen? We obviously know the answer.
I think it's our belief in authority as well, our belief in governments, our belief that these people have got the authority and jurisdiction to do these kind of things, and we've just accepted it. Now, people will look at this and go, yeah, that all happened, or the Pope did issue a bulla and annulled the Magna Carta and all that. Yeah, he did. But that's not legit. That's not legit authority. We should be saying that's void because, for one, King John was bound by his coronation oath and broke the law and can't just decide to make back-alley treaties with the Pope to remove him from that situation. That's not how it works. The head of state, the king at that time, was limited and he didn't have that authority to do that, let alone a foreign pope being able to interfere with constitutional law, with constitutional principles as a foreign state. That doesn't work either, does it? How does that work? And it's just us decides acceptable. And all you need to throw in is that the king had some sort of divine right in 1215 or prior to 1215. No, that wasn't the situation. That came later. Let's not confuse it. This is what we do. We muddy the waters and try and suggest that 1688 is what took care of what was going on from 1215. But our system of governance at that time was way more purer and more legit, and the people played a huge role in that. That's the facts. If you look at the history books, the king was just the first amongst equals. It's the people that you put them in, elect them, or agree with their principles. If they don't, then they just get removed. And that was right from Saxon times, probably before. That was the situation. They had responsibility. They had duties to the people. They were sworn in to protect those laws, to protect individual rights, to make sure trial by jury, common law trial by jury, where the people were in the powerful position of judging. That was all it. King Alfred, I don't know if you remember from the last presentation we did on the Bill of Rights and on the rule of law and all that kind of stuff. But if he found out that judges were sidestepping unanimous decisions or correct protocols, they got hung. He just wiped them out. That's how serious they took those principles. If you were a judge and you tried to sidestep that and you were caught, you're dead. So,
We probably wouldn't have much of a judiciary left if we had that rule back in the day right now.
but that's what it was. Now, what I'm saying now, we certainly need to be having that conversation. We need to be bringing these topics up. We need to be talking about our history and what it was, and not the distorted version. All it takes just to distort the whole situation with constitutional law is for someone to come along and say, in them times, them medieval times, the king had absolute power to do whatever he wanted. That's all it takes. And from then on, everything is completely the Magna Carta, your constitutional law, anything that meant anything or protected anybody is completely down the toilet because of that one comment. And if people take that on as a belief, then you're in trouble because that narrative becomes truth.
And that I have a problem even with that stuff as well, naturally, in that how can I be subject to a scenario, an authority from a time that I wasn't even born in, where someone decided that the king had this ultimate authority over everybody, and that I am now born in this reality and I've got to just accept that as being that's the way it is. It's just bullshit. All man-made crap, isn't it?
I think people's ideas of what it was like at that time is a little bit distorted. People did actually understand what was expected of them in them scenarios. Now, a lot of people just don't care.
Yeah. Apathy.
They don't care enough, even when they attach the freeman of the land stuff to the Magna Carta and all that. It's just to try and dismiss it. Even if you look later on, during COVID and all that, anyone who was pushing back and saying that they were sovereign and this didn't apply and that didn't apply, the media straight away applied that sovereign citizen movement, which is a contradiction in itself, by the way.
Yeah.
You can't be sovereign and be a citizen.
Yeah.
Do you know what I mean? But this is what they do, the play on words, the double thing, the distortion, and people within the freedom movement are guilty of that as well.
Yeah.
All I'm saying is let's have that conversation. If anybody disagrees, then that's fine. If people don't even want to believe that or take that on board, it's fine. You've got the free will choice to believe what you want. At least have the conversation.
Yep. Agreed.
If constitutional law sits above statutory law, then how can the 1297 statute reissue invalidate the Great Charter, which is customary law, constitutional law, common law? Although statute may contain wording of common law, this does not make statute common law. Likewise, if statute is repealed or amended, this does not alter or remove common law. To reiterate, the Magna Carta 1215, which is the original Great Charter, made up of the Articles of Common Law, can't be invalidated by the 1297 statute version or rewritten using statutory law. All statutory law must fall in line with constitutional law. Government should not be legislating anything that is repugnant to the common law constitution, which is the Magna Carta 1215, which would count as a breach of constitutional law. To conclude, governments have no authority or jurisdiction to be involving themselves in matters that aim to alter constitutional law. Their role is to abide by constitutional law. They can't give themselves special powers to start moving the goalposts to suit themselves or to give themselves more control over the people. That's not how it works. Constitutions are there to protect people's individual rights and to bind governments. I can't emphasize that any more than that. That's what it is. That's what your constitution is there to do.
I don't think even anything more is to be said about that because it's simple. It is what it is. I don't know how you argue that.
When you understand that the constitutional law that we've got is the foundation, that everything else around it has to align with that constitutional law. Otherwise, why have you got a constitution?
Yeah, it's completely
Don't have one. Just have statute law and allow the government to dictate what.
That's what they've done, isn't it? That you haven't really got a codified.
This is the whole reason why it's slowly been taken apart And
Yeah.
these kind of narratives people have breathed life into, that it doesn't exist, that it's been repealed. All that nonsense. How can you repeal something that isn't statute?
Yeah.
It's not statute law.
Exactly.
So how can it be repealed?
Common sense, man.
Article 61, the security clause, was removed from the 1297 statute. It seems odd that the clause that acts as a safeguard against the rogue head of state or government was removed from the statute version. Furthermore, Article 61 of the Magna Carta 1215 was invoked in 2001. It was reported by the Telegraph, and the Queen's personal secretary responded, not denying the Magna Carta 1215 or Article 61. Now, if it didn't mean anything, or let me say, if it does mean something, and then you've got your head of state, the Queen, rubbishing constitutional law, then she opens herself up to crimes as well. She opens herself up to sedition. I don't think people look at it like that, but she didn't. She didn't do that. She basically responded through her secretary, and she didn't deny anything that had been said.
Do we know what that response was out of interest? You know,
You can, yeah. I've read it. I read it probably over a year ago now. But it's a weird one. Will Keats sums it up brilliant on commonlawconstitution.org. He's done an article covering it, and he voices his concerns about the reasons why it was invoked. It was surrounding our integration with the EU. But there was a lot of confusion as well. People were still quoting from the Bill of Rights and stuff like that. And that's where the people, even people who've tried to be good, have muddied the waters a little bit, like mixing it up. Instead of just using the Magna Carta and invoking Article 61 for the right reasons, the fact that trial by jury, common law trial by jury, has been diverted. Because at the end of the day, God takes care of it all.
Yeah.
We don't need to go on about EU law or EU integration, because once that trial by jury is back in place, the people decide.
Yeah.
The power isn't with Tony Blair. Do you know what I mean?
Yeah.
That's the causal factor.
Yeah.
So, but going back to that, the real crimes that have been committed have been diverting that one system of governance, that trial by jury, that common law trial by jury, and then mechanisms. That's what's been diverted. That's why Article 61 should have been invoked.
Yeah.
Not for the symptoms. Does that make sense?
Yeah. So it was done in the wrong way then.
We're not concentrating on the causal factors of why governments are able to act criminally and get away with it. We're petitioning and all that kind of stuff, which is good. But what we're doing is we're saying, oh, the Treaty of Nice. The Treaty of Nice isn't the causal factors of why slavery is being imposed on the general population. The main causal factor is because trial by jury has been watered down. And we're no longer in a position of what we have been in the past, where we've been judging not only the defendants, but we've been judging on legislation. We're able to prosecute public servants free of charge. All them articles are there in the Magna Carta, even the articles on usury, borrowing money at rates of interest, fractional reserve banking and all that. It's covered. All of it's covered. It's just that we're not using it.
Yeah, it's nuts, isn't it? This whole thing's nuts.
It is. It really is. So going back to Article 61, taking action under Article 61 is showing allegiance to the legitimate rule of law, trial by jury independence and truth, not necessarily the barons. Now, there's nothing specific to me in Article 61 that there's this one way of showing allegiance, and that's the process that you've got to follow. Now, I know people who take oaths to themselves, showing allegiance to constitutional law. They do write it to barons. They do it that way. But it's showing allegiance to the rule of law, because that's what you want reinstated. What do we do if the barons just ignore it?
Yeah, we have no. Yeah, exactly.
No way, is there? Because it's
recourse.
Well, the barons don't want to know, so the people haven't got a leg to stand on. No, the people have got responsibility and a duty to stand under constitutional law and show allegiance to that. That might be through starting to send notices to councils, to the police, to the courts, whatever it is where you want to start. But that's how I see it. That would be my interpretation, and especially from the reading that I've done with the stuff that Will Key talks about and all that. It's all there, and it even discusses that kind of remedy, just showing allegiance to the rule of law away from the treasonous regime. This is only in alignment with natural law and what is already expected of people, which is to call out the lies, wrongdoing, and all immoral acts that violate people's natural rights. It will ultimately avoid any behavioral consequences we receive back for not acting in defense of truth, morality, and natural law. Forget about Magna Carta at the moment. This is what we should be doing, regardless of. We should be calling out wrong behavior. We should be defending truth, natural law. That's what it's really about, morality. The Magna Carta and the constitutional law just allows us to exercise that morality, to raise that level of consciousness, to understand right and wrong behavior.
Okay, guys, so at this part of the video, we're coming into the latter stages now. Damien is going to focus on all of the misconceptions around the Magna Carta, what it was like at the time, some historical facts I think that aren't being talked about out there, to give you a completely different perspective of that same situation, and you can correlate that with your own research and what other people may be saying. With that said, Damien, go on, man, get right into it.
I'll just get straight in, mate. There was no divine right of kings in 1215 or prior to 1215. No absolute power. That dogma came much later. King John was simply the first amongst equals. All heads of state were bound by coronation oath to uphold the Lord of the land, legem terri. It is the Latin for Lord of the land. Common law trial by jury. What did that mean? It meant he had limitations placed upon him. He was a limited monarchy. He would have delegitimized himself by not agreeing to the terms of his coronation before taking on that role. To suggest that he had legitimate authority to give the nation away is somewhat ridiculous given these circumstances. Suggesting that the Lord of the land died when the king died is also a stretch of the imagination. The Lord of the land stood in perpetuity. A new king could not cherry-pick what laws he wanted to abide by and disregard what he didn't like. Again, these limitations would have been set out in his coronation oath. Without this, a nation is open to tyranny and dictatorship. King John sealed the Magna Carta 1215 under duress, and rightly he had broken the law and his coronation oath. He was guilty of committing horrific crimes on his own people. The barons, as his social equals, had the duty and the responsibility to restrain King John, calling out immoral acts and wrong behavior under natural law, a duty all people have and should exercise. We've already spoke about it, but I just want to emphasize there was no divine right of kings. There was no absolute monarchy. There was no king that could just decide to give the country away or to make a foreign state is a pope, is feudal overlord.
That kills it. The fact that there was no divine right of kings back then, and it's easy to see how that narrative comes in later on, and then it's just automatically assumed that it applied back then as well. And so when they say, oh, John gave it to the Pope, oh, that's okay then. But it's your point that the facts speak the facts, and the facts are he had no authority, and that's it. So the whole narrative is dead.
Exactly. Straight from the get-go.
That's what I mean. That's
his own coronation mean that there's no feudal overlord. There's no Pope taking jurisdiction of constitutional law or of land.
Really, it could be argued that there's an act of treason.
Oh, yeah, of course.
Yeah, absolutely committed treason.
Of course. I've been hit with that on social media so many times that King John made the Pope as feudal overlord. And even when you state these facts, they're not prepared to go back in history and look at the fact that all heads of state, all kings were just the first amongst equals. They have a duty and a responsibility to people's individual rights, to the rule of law.
Absolutely.
It's not simple.
I think the other thing for folks out there, maybe on social media, following threads or whatever it may be, is to understand that if you can understand that this is the Constitution and how simple that is by the fact that There was no divine right of kings at the time. Therefore, he had no authority to do any of this. Is it any wonder that they go to such lengths to bury this information? So what I'm trying to say is that it's absolutely true that on social media now, in this truth movement right now, there are people that are placed there to intentionally misdirect us when we're trying to learn that truth. So the key thing is it's obviously do your own research, use your own discernment, but focus on the simple facts and ask the simple questions. And if your own mind can't come up with simple answers to simple questions, there's your answer.
I've heard a few times as well that when the king died and the new king came to the throne, he was able to just cherry pick whatever laws he wanted. No, that's not the case at all. Again, that's just another misconception. He would have took a coronation and he would have been bound by the same
By the oath.
law of the land, the same common law. The fact that it took dismantled the Constitution over a long period of time. Now, if it was that easy to do, it would have just been done straight away.
Yeah.
The fact that it took them so long to slowly chip away at it and do little sneaky things here and there tells you that it's not easy to do.
I think the other thing as well, I've got no proof of this, but it could not make sense, is that if the 1215 Magna Carta was basically just completely illegitimate anyway, why create the statute version as a carbon copy and then repeal everything? You wouldn't even do any of that. It wouldn't even have had to have happened.
No, because people wanted them things in place. That's probably
That's why I think
the issued so many times, because they were just rebelling against the king and saying, no, we're not having that, or they weren't happy. So the king, to try and sway the people, would reissue the charter and say, oh yeah, even in the 1297 version, if you read it, it even says that he's just bringing back the original Magna Carta. The principles are already there. The trial by jury, they're the existing articles that haven't been repealed, which is fair enough. I'm not arguing that case. I know the principles are there. Governments have still had the opportunity to repeal it because they created it, so they can still case. Even when you talk about the Bill of Rights, there's still sections of the Bill of Rights that have been removed, been repealed, and you can quite easily evidence that. Section 3 of the Bill of Rights is not there. You can't read it on the legislation website. I've read it. It's showing allegiance to the charters, and it's basically saying that this bill doesn't invalidate any charter that came before it. That's why it's been repealed.
It's always the way that when you do, like you point, I didn't even actually know that myself, but again, it's obvious why it's fucking repealed.
This is it. These are the little moves.
Behind the dots, folks.
It's not all the moves we've ever done, but these are the sneaky moves that have huge impact on what we think, on what we believe, on what our perception is. If we don't decide to use our own discernment and actually look at history and look at these documents, look at what even the Glorious Revolution is and what you think it is from mainstream narrative. And that's another video I'm going to do further down the line. I've already put it together. That's going to shock a lot of people as well. The Magna Carta 1215 did not spawn common law, legem terrae, the law of the land. This was just a document stating what already existed. Common law and common law trial by jury was already in place in parts of Europe hundreds of years before Magna Carta was drawn up. You can also see from our late Saxon kings, Alfred the Great, and a bit later on, Edward the Confessor, hundreds of years before Magna Carta, that these customs were common practice. King John was already bound by the law of the land before the events of 1215. The barons had to convene a common law court to deal with his breaches, which led to the sealing of Magna Carta. King John made Pope Innocent III his feudal overlord. As already explained, John was bound by his coronation oath and the lord of the land. He had no authority or absolute power as a limited head of state to make the decision to give England away to a foreign state. Another one, Pope Innocent III annulled Magna Carta. The Pope had no right to interfere with constitutional affairs or secular matters concerning land. These actions were ultra vires. If King John didn't have absolute power to give England away, where did the Pope and a foreign state's authority to intervene come from? Simply, there wasn't any. Again, calling out the lies, wrongdoing, and immoral behaviour under natural law. We've already discussed this, mate. I don't think there's much to say on this one.
I think so too.
It speaks for itself. The histories that you go back to Saxon times, even before, go to Europe, was going on. Same principles, trial by jury. Right, what we're going to do next, mate, is talk about the Bill of Rights.
Okay, sweet.
I'm not going to talk about the 1225. There was loads more after that. The main one is the 1297, the Confirmatio Cartarum that people talk about. So it was basically from that to that. The next constitutional documents, we've had loads, habeas corpus, the Petition of Rights. I'll discuss them all, but they're all statute law. Can be amended, it can be repealed.
Yeah.
I get into the whole fact that Prince William was guilty of the same crimes. Bills of attainder, basically taken away somebody's rights to trial by jury to get a guilty verdict.
No, wow.
They're in cases of treason. This was when the whole Glorious Revolution happened and there was still pushback. There was still people conspiring. And that's what he did. He basically removed, that's the bill, a bill of attainder, to remove somebody's individual rights to a fair trial, to just basically find them guilty and hang them.
This is what people need to see, 'cause especially with all the commentary about the Bill of Rights right now.
Because what people think is, oh, James was this, James was that. It's not true, mate. Although James was a prick, he still had certain principles. It wasn't all bad. All he wanted, really, was religious freedom. What we've got now, that's all he fought for. Because it was predominantly Protestants and everyone was terrified of Catholicism and Catholics. That's the only reason.
So this was just it was just another religious battle.
Yeah, it was not the bishops.
Yeah.
Because he was basically trying to put Catholics into the church, into position.
In an upcoming discussion, Gavin and Damien delve deep into the historical landscape of the Bill of Rights and its pivotal moments. We'll explore beyond the 1225 document to the 1297 confirm RTO court order and other significant constitutional texts like habeas corpus and the Petition of Rights. Discover how statute law can be amended or repealed and the controversial actions of Prince William, who used bills of attainder to strip away the right to trial by jury. We'll also tackle the Glorious Revolution's impact and debunk myths surrounding figures like King James, shedding light on the religious conflicts of the era. Don't miss this riveting discussion that brings clarity to the Bill of Rights and its enduring influence on our freedoms. Stay tuned as there is much more to come. Be sure to click the notifications when subscribing so you don't miss any of our enlightening discussions, all part of Sovereign Empowerment's effort to help you live a life of freedom.
Ever grappled with the labyrinth that is the legal system? It's a maze of jargon, procedures, and power plays that can stump even the most intelligent among us. Enter How to Win in Court, a transformative course designed to level the playing field. Brought to you by the dynamic partnership of Sovereign Empowerment and Dr. Frederick Graves. This course is like a compass, guiding you through the intricate passages of the legal system. It provides powerful case-winning strategies and tools for controlling solicitors and persuading judges. This isn't just about understanding the law, it's about empowering you to use the law to your advantage. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with confidence. Imagine having step-by-step instructions at your fingertips, demystifying the complex world of court cases. With How to Win in Court, that's precisely what you'll get. There's a treasure trove of sample forms, video seminars, audio clips, and comprehensive classes waiting for you. Finally, you'll have all the tools you need to persuade and control judges in any case or court. The beauty of this course is its accessibility. Whether you're an early bird or a night owl, you can dive into the course material anytime with round-the-clock online access. And no matter the device, be it your smartphone, tablet, or laptop, you'll have seamless access to the course. You'll also gain access to invaluable tools like the free online legal research tool, legal dictionary, and a Q&A forum. Learn from a seasoned attorney with over 40 years of winning experience who has distilled his expertise into this comprehensive program. These resources are like having a personal legal advisor, always ready to assist you, but without having to pay exorbitant legal fees. For those struggling to afford a solicitor, this course is a beacon of hope. Good people have suffered too long at the hands of power because they didn't know how to fight back, or they didn't have access to the right resources. Now, in a matter of just a few days, you can acquire the tools and the knowledge that it takes law students years to achieve. With the right knowledge and tools, you'll be able to navigate the legal waters with confidence, winning your case without expensive legal representation. Alternatively, if you already have a solicitor, you can equip them with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. And the cherry on top? Upon course completion, you'll receive an honorary law degree, a testament to your newfound legal prowess. No matter what court, civil or criminal, you'll be able to conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. That's right, the power to navigate the legal system is now within your reach. All it takes is the will to learn and the courage to empower yourself. Everyone deserves access to the right legal knowledge. That's why we offer the jurisdictionary law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. So why wait? Enroll in the jurisdictionary course today and take that first step towards legal empowerment. How to Win in Court has become the most trusted law course worldwide for almost 30 years. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Your journey to mastering the legal system starts here. When you have access to the right resources, you will become a force to be reckoned with in any courtroom. So click the link now to become empowered with all the information you'll ever need to know how to win in court. Learn how to use the court system that is there to protect you, your family, your property, and most of all, your rights.